the Special Marriage Act, the Foreign Marriage Act, and provisions for OCI card holders under the Citizenship Act that constitute a self-contained part to grant entitlements based on registration, recognition of foreign marriages. My lords, I will briefly describe the first two sets of points and then deal with the third first, because nobody has
Now
read
let's
through
see
the
the
third
summary of submissions.
yet. I beg your pardon, my lord?
Let's go through the summary of submissions now.
Yes, my lords. First, my lords, under the Special Marriage Act, it has been submitted that 99.9% of people fall in the gender binary and are men or women, whether they are queer or trans or straight. My lords, we adopt the other arguments of Dr. Singhvi, but my lords, on this point, we differ. The 2011 census itself showed that there are at least 4.8 million, and this is a huge underestimate, my lords, of trans people in this country. Many of them, my lords, are in this courtroom, and I mention this because of the way that they have been demonized in the public. Ms. Muskan Tibrewala, who has rendered excellent assistance, is one such person who is going through a coming out space and has given this permission to me.
Your first point is you have referred to section 3 and section 2K.
Yes, my lords.
The 3 speaks of non-discrimination against non-binary persons. That's fair enough.
Yes.
Then the next point which you are saying, that is, just explain that. You say that Rule 5 of the transgender rules already recognizes marriage of trans persons. What is can you read out the rule for a second?
There are the rule.
Is a rule in that book?
Can I have the rule?
Sure,
Rule is in the book. Can I have rule 5?
Yes, it is. Rule is there.
Where is it? It's not 3 pages. No.
Yes, here it is.
Rule 5, right?
Yes, my lords. My lords, Rule 5 refers to the application for certificate of identity. Do my lords have it?
Yes, we do.
No, but Rule 5 is issue of certificate of identity, right?
What? 6 is issue of certificate of identity, my lord.
No,
5.
5.
Take time to download.
We have the 2023 Act, my lord.
No, we have a 2020 rules.
I mean, we have the 2023.
Yeah,
Rules have changed.
2020 rules.
If you saying that 23.
I beg your pardon, my lords.
Rules are 2020, right?
Issue of certificate of identity for a transgender person under section 6.
No. 6 is procedure for issue of a certificate of identity. 5 is issue of certificate of identity. Right?
Yes, ma'am.
Which one are you looking at? 5 or 6?
My lady, under these two rules, a certificate of identity is issued to trans people.
Yes.
In that regard, an affidavit is required to be submitted, and the form of that affidavit is provided in the rules itself. So it is the forms that I am on more than the rules. The rule is the power to issue the form, and I am now on the form.
But when you say Rule 5 already recognizes marriage of trans persons, where do we get that from? Because that's an important point.
My lord, it's more that the form acknowledges.
Where is the form? Which page is the form?
Form is at page 3224.
No, it's here also in the
Form
number.
Justice, in page 17 of this act, if you have it.
The form is at.
Actually,
Form
Justice,
5.
I think let us focus on page 17 of the Act.
Yes.
Oh. I'm sorry, my Lord Justice. I can't see the judge.
You have the enactment, so you can see the Act. Page 17 contains the form.
Yes, that's what it is. Form 1.
Right.
Yes, Form 1.
2D, 3.1 and 6.1. So we suppose this is the form you are relying upon to say that.
The next page, my lords, is Form 2. I have page 19. I have the 2023 Act.
That's fine.
It's a
23 Act.
What
There's
is
no
this
23 Act.
23 version.
2019 Act.
2023 version.
Yeah.
It is the 2019 Act.
Right.
But because I'm referring to page numbers, this is the version that I have.
Form 2.
Form 2. Form 2, do my lords have it? It says,
We do.
I, the form of affidavit to be submitted by a person applying for certificate of identity for transgender persons under Rule 4 of the Transgender Persons Protections Act Rules 2020, read with Section 6 of the Transgender Persons
Most
Protection of
important is
Rights
I
Act.
perceive myself as a transgender person whose gender does not match with the gender assigned at birth.
Yes, my lords. I declare myself as transgender.
Right.
But the top part says, I, so-and-so, son/daughter/ward/spouse of.
Right. So a person who is already in a marital relationship
Yes.
can therefore seek a gender reassignment, like
Or
by
a
virtue of form.
self-declared identification, precisely what has fallen from my lords. Indeed, as my lords Justice Bhatt had said, there is no, some people may seek a divorce pursuant to this. Many people in our society will not. And there is no bar in this regard in the Act, and the Act is
So
silent.
it already recognizes the, say, a pre-existing marriage of a person who is trans.
My lords, the pre-existing marriage, but also the subsisting marriage. Because when
Right,
they
right.
transition
Pre-existing,
and after they transition, it continues to subsist.
Correct. There is no bar in law.
Right.
Then there is no bar in law.
Somebody who seeks to assert their identity as trans
Yes.
may well be in a marital relationship at the
Precisely.
point of time when they assert that identity.
Yes. But they also continue to be in that relationship.
Right.
And that relationship under law is not dissolved or annulled or taken away from them.
Yes.
The law accommodates it because these are not grounds for nullity or divorce by the other spouse, because there are possibilities, various myriad possibilities that there could be children, there are dependent families. So there's general acceptance. If somebody has a problem, they will seek out in individual cases whatever needs to be done.
I'm grateful, my lords. That's exactly our point. My lords, there is another mention of this in Form 6. And the illustrative list of documents on the next page includes a marriage certificate at item 12.
No, this applies only for both this and Form 2 will apply to married people who seek that identity as transgenders.
Precisely, my lord.
Right? These forms accommodate such people.
Yes, my lord.
The rule makers have contemplated situations where people seek this gender role, or rather regender themselves, if one could use that expression.
Yes, my
To
lord.
this extent, they recognize and acknowledge that there could be pre-existing marriages.
Yes, my lord.
Mr. Nandi, is it your case that because the rules recognize the concept of a pre-existing marriage in such a scenario, that itself amounts to a permission to have a marriage after such change? Is that what you are seeking to? So, see, there's a pre-existing relationship which will continue. As Justice Bhatt said, it may not dissolve because there may be many ramifications which may arise from such declaring the marriage a nullity or something. So it accommodates that viewpoint. But does that imply that after change, if suppose you are unmarried and there is a change, you can marry? Is that what you are trying to say?
No, that would be my set of arguments that I have made in my larger written submissions, my lords, on constitutionality and harmonization. But my lords, that is precisely right. What I am saying right at this point is that the state already recognizes through delegated legislation and the forms that have been issued under that delegated legislation, some trans marriages, and that some at the moment is restricted to marriages that were pre-existing prior to my declaration of identity
Be clear
or
that
transition
ma-
biologically.
the marriage recognition is
Yes,
between the marriage was solemnized at a time when both parties were not trans. Neither of them were trans.
True. But it subsists because
Let-
there is no bar-in-law as had fallen from my lords.
Let me complete. Perhaps there is no ground for divorce in marriage laws. Therefore, there is a recognition of the fact that once somebody finds himself in this situation, we will not disturb it. Because once you start disturbing, there could be other consequence. So you recognize that situation.
Yes,
That is one thing to accommodate in the form of rules or even forms. Now we are not talking about rules, we are looking at forms.
yes, my lords.
If we are to transform that into substantive provision and work backwards, as it were, there should be some statutory support for that.
Yes, my lords.
Because unless you state that, for instance, Section 3 or whichever provision says there shall be no discrimination, and then goes on to say in what aspects, like you have in Section
continue
47
to be
of
married.
Disabilities Act. So
Yes,
what are the rights and what are the obligations, what rights of these persons who claim these identities, and what are the obligations of society? The legal obligations are also spelled out. So if your argument is built around these forms, then you'll have to go further.
My lords, the argument is precisely the way that had fallen from my lords, Justice Bhatt. We have said, for example, that it has been said in this court, during these proceedings, that trans and non-binary people are elite, that small portion, etc., my lords. The
Miss-
first point addresses that. The second point is on the non-discrimination, my lords.
This elite argument you can just keep aside because we are now going into the core constitutional issues and core statutory issues.
Yes, my lords.
So, elite is a matter of prejudice. I mean, but it has no bearing on how we decide the matter.
I'm grateful. Let's
Actually, these two forms which you showed us, the first form, Form 2, is at the stage when you apply for a gender identity certificate.
Yes, my lords.
Form 6 is after a gender as reassignment takes place. Because if you see Rule 7.4,
With the ID.
Form 6 is to be read with Rule 7.4 because that's that's in the title of Form 6. And 7.4 says the district magistrate, while issuing the certificate of identity for change of gender, shall simultaneously issue an identity card in Form 6 to the applicant.
Yes, my lords.
And that form in item 12 refers to marriage certificate. So these two forms seem to indicate that both when a person applies for a gender certificate in Form 2 and the issuance of a reassignment in certificate in Form 6, they do contemplate that somebody could be a party to a valid marriage because they or an subsisting marriage.
The
Precisely.
position as it existed at the time of the grant of the certificate is what is contemplated, without anything more.
But also, as my Lord the Chief Justice had pointed out, that after the gender reassignment surgery is done, the situation is different.
Correct. This is
And then,
No, but Ms. Nandi, if you see the Act also,
yes, my lady.
Section
Yes,
5, 6, they refer to application for certificate of identity. They refer to issuance of certificate. 7 talks of change in gender and specifically says that it is, if you will read that an application may be made along with the details of the institution where the person has undergone surgery. So the whole idea is so that the certificate can be revised. The context is of 4, 5, and 6 is issuance of certificate of identity.
Yes, my
In the course of that,
Yes.
the status of that person, as it were, is reflected from one of the columns, but that's about it. So how do you propose to take it further?
My lady, the
Build
point
your
is
argument.
this. My lady, what I am saying is this. is that the law recognizes under Section 2K the range of gender identity. In Section 3, if we may come to that, (3)(e) specifically,
Yes, please.
prohibition against discrimination, 3E says the denial or discontinuation of or unfair treatment with regard to access to or provision or enjoyment or use of any goods, accommodation, service, facility, benefit, privilege, or opportunity dedicated to the use of general public or customarily available to the general public. So it's a broad non-discrimination provision. In addition, and this is my third point, that this is not happenstance.
You're right, it's not happenstance.
Because of Nalsa, my lady.
But then this is a right which is available under 15.2 to some extent.
Precisely, I'm grateful to
Don't
my
need-
Lord's Justice, but this is
don't need a NALSA. 15.2 encapsulates that. It's a wide horizontal right, right? So, I mean, to take your logic, let us go to Rule 5. Rule 5 talks of issue of certificate of identity. Right? It says the certificate, number 3, sub-rule 3, certificate of identity issued under sub-rule 1 shall be the basis of change of gender as well as the name and photograph if so necessitated in all such official documents as provided in Annexure 1. Now, what is Annexure 1? We don't have that in this.
Annexure 1 is perhaps what is at page 23. It refers to Annexure 1, brother. Card issue date, signature
Annexure
of
one is there.
Annexure
Same
1
thing,
is
the page-
illustrative list of official documents referred to in the name of the official document.
it's titled Annexure 1, as my lady has pointed out, above the table.
Page
Part of
23.
Form 6. It is Annexure 1.
No, it's not.
It's a part of Annexure 1.
Annexure 1 is not part of
No.
Form 6, it's an
It is
independent
not.
annexure. And this is something relatable to Rule 5.
Yes.
So, just to take the thought further, Ms. Nandi, not
Yes,
everyone
Manoj.
has a marriage certificate. Not everyone has a marriage certificate.
Yes, my lords.
You agree?
Yes, my lords. Not everybody has a marriage certificate. Some transgender marriages continue to subsist.
No, I'm not talking of that. I'm talking generally.
Yes, my lords. But
Matrimonial,
yes, not everyone has a marriage certificate.
because marriage certificate is a civil kind of form which is not mandated by any personal law. There is no compulsion except maybe in some states
Absolutely.
certificate. The only
Absolutely.
certificate which is mandated is under the Special Marriage Act, because that is the only form of marriage between those two classes of persons who belong to different communities, right? So a marriage certificate itself might pose a problem for anyone.
Yes, my lords.
Yes.
My lords, I am only pointing out the current situation and
Yes.
pointing out that currently that there are some transgender marriages that at the point of transition are recognized to subsist. There are other transgender marriages that are not. Either they do not have the marriage certificate, or they cannot marry the person they love only because of the timing. That is my point, my lords.
See, that point is, I mean, you have made your point, but the point, there is a distinction, which is that those who are married as not transsexuals, as heterosexual couples, a heteronormative based marriage, so to say, later turns out to be one where one recognizes her gender not as a female or male, but as a transgender person. At that stage, the law enables this much, and it also does not upset the pre-existing.
Yes, my lords.
Exactly.
Now your dilemma is the next step, which is that having recognized the pre-existing relationship, you have not enabled two transgender persons to come together and celebrate their union in
Yes.
matrimony. That is your dilemma.
Yes, my lords.
Where you're saying, no, you can't locate that within the enactment. To the
We are
extent
not.
that
We
the
are
law
not.
recognizes this,
Purpose of
but you have to go beyond that, and there you have to fall back on the same arguments which are made by your predecessors.
By many counsel before me and by me, but I will not repeat them in the interests of brevity, my lords. But that is precisely, my lords, what our burden is, to discharge the burden of constitutionality as it relates to the argument that goes beyond the forms. And my written submissions, my longer written submissions, which is in compilation 1, address all of those arguments as well, my lords.
What is the next point?
The next point, my lords, is just to say that this is not happenstance, that the Transgender Act of the Union, not so long ago, only 4 years ago, was enacted pursuant to NALSA. And what NALSA says at para 119, and I've reproduced the part for convenience, that therefore gender identity becomes a very essential component which is required for enjoying civil rights by this community, viz. the right to vote, the right to own property, the right to marry. On workability, my lords, on workability, I have worked it out, and my respectful submission is that there are only two doctrinal principles that need to be applied for a minimal reading in. The first is this, that husband and wife should not be collapsed into the same category, my lords. And there should not be one gender neutral category of spouse. Because the heightened protections that are given to women emerging from Article 15.3 are there for a reason. So what we have proposed in this note, but the reason we didn't file it because we would like to hear what the other side has to say. But this is the current formulation. Is that third gender spouse, which is a phrase used in NALSA. It has been critiqued. So non-binary can also be used in this regard. May be used along with husband or wife. And of course, husband or wife must include trans husband or wife. As the Madras High Court did for the Hindu Marriage Act in Arun Kumar, that judgment is in my compilation. I'm not going into it because it's the Hindu Marriage Act. But that's the way the Madras High Court had worked it out. The second doctrinal principle, my lords, is this, that
Can you send this one email to the court master so that he can then email it to justice?
we will do it in the next 10 seconds. We weren't planning to hand it over, my lords, but
So you are saying, I'm sorry, Ms. Nandi, there was a lag here. I think perhaps Justice Call also explained.
yes, my lord. Shall I repeat what I said, my lord?
First you said that you do not want a neutral phrase like spouse. You don't want to collapse the gender
Basically,
in the enactment because
Brother Bhatt and Justice Call,
Yes.
what Ms. Nandi's tabulated statement which she has given us now,
Yes.
seeks to interpose the word or third gender person
Uh,
in various provisions of the Act, including Section 2B. So, for instance, in 2B, she says a man or third gender person. Likewise, a woman or third gender person. In Section 4, which deals with conditions relating to solemnization of special marriages, the male has completed the age of 21 years and the female or third gender person, the age of 18 years. Likewise, in section 12, I so-and-so take B to be my lawful wife or husband or third gender person. So
spouse.
then spouses instead of husband and wife. In section 20, in 15, husband or wife or third gender spouse in section 22.
So I think it goes on then.
That goes on, exactly.
So
Just to
then,
emphasize, my lords, that I used third gender because it comes from Nalsa and it has precedent in law. But it has been critiqued by the communities. And so non-binary would serve just as well. Non-binary person or non-binary spouse.
Ms. Nandi, so then you
Lords.
comment that the approach of the Madras High Court should be adopted in regard to all this. We understand that. The only question is, where do you perceive the conflict between your position and the position by the predecessor council? Because that is something we have to iron out.
Yes, my lords. My lords, the Madras High Court supports this workability note only to the extent that man or woman includes trans man and trans woman. What we have added here, my lords, is non-binary persons based on two doctrines: differential protection for women to be preserved, and that heightened protection also be provided to non-binary transgender persons due to the fact that in line with Article 15.2 to 15.4, NALSA requires the union to provide special provisions for transgenders and affirmative action as social and economic backward classes. So there is a ground because of historic discrimination in para 67 and 68. Read out the paras. This is at volume 1. Shall I come to that, Manu?
Yes.
This is volume 1, compilation 4, PDF 792, and paperbook para 761. I'm on para 67. Transgenders have been systematically denied the rights under Article 15.2, that is not to be subjected to any disability, liability, restriction or condition in regard to access to public places. Transgenders have also not been afforded special provisions envisaged, and my lords may note envisaged already, under Article 15.4 for the advancement of the socially and educationally backward classes, SEBC, of citizens, which they are, and hence legally entitled and eligible to get the benefits of SEBC. State is bound to take some affirmative action for their advancement so the injustice done to them for centuries would be remedied. Transgenders are also entitled to enjoy economic, social, cultural, and political rights without discrimination, because forms of discrimination on the ground of gender are violative of fundamental freedoms and human rights. Transgenders have also been denied rights under Article
All right, Ms. Nandi, we've seen Talsa. Now, should we go back to your statement, actually, so that, that's page 2, so
Yes,
that
sir.
we can just look at it and then we can wrap up, I think.
My lords, I have 2 additional points, if I may, and my third point is one that nobody else is raising.
Yes.
So I'll go through this very fast and then come to my third point.
Yes.
So 15.2 to 15.4, my lords.
Where are you reading?
Differential.
Where are you reading in your
Part of the statement are you on?
which page? Which page of your statement?
I finished page 1 and I am turning to page 2 to deal with the Foreign Marriage Act.
Yes, okay.
My lords,
Submission
should this court
26.
only read the Special Marriage Act inclusively, an immediate Article 14 anomaly will arise. The Statement of Objects and Reasons in the Foreign Marriage Act explicitly and repeatedly states that the FMA is pari materia to the SMA and incorporates provisions of the SMA by reference. So the FMA applies when one party is an Indian citizen and the marriage is solemnized outside India. So for clarity, it doesn't apply to two foreigners. However, the same Indian foreign couple may come to India to marry under the Special Marriage Act because the judgment that I have placed on record, and I've only placed one, it is of 2023 by Justice Pratibha Singh, and she has detailed the other case law that also says the same thing. And it holds that even two foreigners, male and female, can marry under the Special Marriage Act because Section 4 uses the term any two persons and not citizens. So if the Foreign Marriage Act does not follow the Special Marriage Act in being read in a gender-inclusive manner, same-sex, queer, and transgender couples may marry in India, my lords may scratch out or at a consulate, may marry in India, but if they are already married on foreign soil, they will not be able to have their marriage registered by an Indian marriage officer under the Foreign Marriage Act, Section 17. The reason is that 17 refers back to Section 4. And Section 4 is the only place where gender-specific terms bride and bridegroom have been used. And we have done this workability exercise, my lords, and placed the Foreign Marriage Act provisions also under the table that we have submitted to my lords. We will refine it if required, if there are submissions in this regard from the other side. But my lords, the rest of the Act, if Section 4 is read inclusively and in accordance with a declaration or the Special Marriage Act, falls almost automatically into place.
So then now your final point, which is?
My final point is that there is a third category of persons. And this third category of persons are represented only in my petition. They are left in a catch-22 situation. We are married OCI persons with families who choose to live here. Some of us, and some who have deep roots in this country. Many have been Indian and then moved abroad and, I beg your pardon? And become OCI. They cannot marry under the Special Marriage Act because the third schedule requires a declaration that one is not married. They cannot marry under the Foreign Marriage Act because that only applies to an Indian citizen marrying a foreign citizen.
Who is there before us of that category?
So before you, my lords, are Kamakshi Raghavan and Melissa Ferrier.
Want to see if any of those people fall in the category that you are mentioning.
Yes, my lords. My lords, if I may have the leave of the court to say a little bit about Kamakshi Raghavan and Melissa Ferrier.
You said that they cannot marry under the SMA because the third schedule applies to persons who are not married.
Yes.
And they cannot marry under the FMA because?
One party must be Indian and one party must be foreign. Here, for my petitioners, one party is OCI and a foreign citizen, and the other party is foreign. And if I may tell, as had fallen from my Lord Justice Bhatt, just a little about Kamakshi and Melissa.
Yes, we can. Can we decide constitutional validity on individual cases? You know, I mean, validity of a provision doesn't become suspect because of, it causes injustice in individual cases. You have to look at the constitutional validity of a provision from the larger perspective.
Shall we look at the plain words of the provision, my lords? But first, if I may tell my lords a little bit about this couple.
See, we have
With my Lord Justice Bhatt's permission, If I have time in the end, shall I do that? And shall we go to the section itself?
Classical statement of law was by Justice Krishna in R.S. Joshi versus Ajit Mills, that you know.
My lords, I am on constitutionality. Hardship is only a supportive argument. And constitutionality...
My question was not an invitation to outline the facts, because when we are deciding, none of the previous council have outlined any facts except the barest minimum, because if we are to, then we would delegate this matter somewhere else. So tell us how this, the only thing, one sentence, how is it relevant or is it not in your petition? If it is not, it is moot. Why should we decide it? If it is, then you say so and proceed. That's all.
So why don't you summarize now, you know, as we are concluding, give us the core of your submission. Why don't you summarize it now so that we can then note it and then we'll conclude.
Let me summarize my submission with regard to the Citizenship Act. As had fallen from this Honorable Court and from Justice Bhatt in particular, that is there a segregable provision with no prohibition in the enactment in which certain things which can be done straight away without entering other arenas in enactments where there is no express prohibition of the remedies sought. I have reproduced Section 7A1D of the registration of overseas citizens of India card holder in the note itself. My lord, we have also requested the courtmaster to keep the act ready. The provision is clear. If I may read it briefly. Registration of overseas citizen of India card holder, the spouse of foreign origin of a citizen of India. This would, or if my lords find in my favor in the Foreign Marriage Act, this would automatically be recognized. Or spouse of foreign origin of an overseas citizen of India card holder, registered under Section 7A and whose marriage has been registered and subsisted